membership any of our programs in the Department of Correction. We have no idea if any of the programs actually work or not. And that's something that we should know because people are depending on these programs to make sure they work because they're depending on them to, improve their lives. So the DOC can do this at no additional cost to the state or to the taxpayer using the data they have right now. I'm going to skip getting into the nuances of how to measure programs for the sake of time, but this is something that the time has come really should require the DOC to report on its programs to find out whether or not they actually reduce recidivism. And if we find out a program doesn't work, it doesn't mean we have a program. There's still a need for the program. What we want to do is actually reform the program, find out why it's not working. That's the direction we want to go in. Lastly, I'm just going to touch on the mandatory minimum issue. District Attorney Connolly has made a comment, something to the effect of criminologists overwhelmingly will agree that mandatory minimums reduce crime. I'm a criminologist. I know a lot of criminologists. He is flat out wrong. The research is not on his side. A lot of what he said was distortions of what the data is actually saying. He was cherry picking. I'd love to sit down and have a coffee with him sometime. So with that, I'll go ahead and yield it. Thank you.
Thank you, Mary Keith from the 15th Worcester District, and thank you for your patience. I would like to speak to another priority of the Harvard Junction Caucus, and that is medical parole. Specifically, we are supporting Senate Bill 874, filed by Senator Jalen, and House 3494, filed by Chair Cronin and Rep. Kane. I thought Representative Kane did a really good job sort of explaining this bill, and I'm sure you're familiar, so I'm just going to hit on some of the high notes. We wanted to talk just a little bit about this bill as having tremendous economic benefits in terms of money that would be saved, but more to the heart that this is simply the right thing to do and a compassionate thing to do. Massachusetts is currently only one of 5 states that does not have a medical parole procedure to release terminally ill or dying inmates. And the DOC reported that the state is spending over $100 million a year in healthcare costs for this population. In 2015, the DOC reported that there were 70 individuals who would currently qualify for medical parole if such a system existed. And though if we had a system in place, a lot of those costs would be shifted to mass health. Much of the spending would be matched with federal dollars as well, hopefully. And this is a population that we all know is growing, even though our population, our incarcerated population is declining. During this period of time since 2000, we've seen the population overall drop for 10%, yet the number of inmates over 50 has increased by 242%, and over 60 has increased by 341%. And I have with me today my good friend and constituent, Osvaldo Ruiz, and I asked him to come today because early on after I got into office, we worked together to get his family connected with his brother Carlos that was at Shattuck Hospital, and he's just going to share what that experience was like. So thank you very much.
Hi, my name is Osvaldo Ruiz. Totally we have my brother, Carlos Ruiz. He ended up with South Correction, and he was just put up, using drugs, and he had a minor case, and because of the minor case, they wouldn't give him a little bail. So, next thing we know, we didn't hear from him, and he was in Shattuck Hospital. When we found out, we go to Shattuck Hospital, and we go see him. It was like, went to see my brother, and he just coughed him up, in his mouth. And after I seen him, half hour later, he passed away. So, I think this bill will be something good to help
So just part of the story is that the family didn't know when he had been released to Chicago Hospital. And so they had to go back to find out that in fact he was in the hospital. He had suffered a major stroke. And even when the family came, Carlos was unresponsive, and their presence alone had him put his hand on his heart. And so obviously he should have been home with his family. So we just want to share this.
Thank you, Mr. Reese, for sharing your story. Thank you very much. Any questions? No questions? Thank you. Okay, we have a panel, Sarah Sullivan, Zach Hyden, and Ronald LaRue.
Thank you, Chair Cronin and Chair Brownsberger. I'm Bonnie Tenerello from Prisoners Legal Services, also on this panel, addressing 4 pieces of proposed legislation on solitary confinement. I'm going to discuss how these bills address real problems in Massachusetts. Sarah Sullivan from the Vera Institute will tell you more about the success of reform nationally. You'll hear from Zach Hayden, the ACLU Maine, about Maine's tremendous successes, and you'll hear from Ron Brial, the former longtime DOC administrator, about solitary confinement here in Massachusetts. Right now, Massachusetts relies too much on solitary, invests too little in rehabilitation. None of the proposed bills will force the Department of Correction to put any prisoner in general population who poses a risk to safety. I can't emphasize that enough. Right now, prisoners are sent up to 10 years disciplinary segregation, the DDU, Departmental Disciplinary Unit, with no hope for release. 10 years per offense, no hope for release, no normal social contact, no programs, no pathway out, only despair and deterioration. We're going to hear later today from survivors of solitary confinement, their loved ones, and former DOC clinicians about the horrible mental health toll that solitary confinement takes on prisoners. We're going to focus on the common sense reasons why solitary can and should be reformed right now. In addition to DDU segregation, there's administrative segregation where people are taken from the general population, put in segregation for all kinds of reasons. Maybe they're awaiting transfer, maybe they're under investigation. What the proposed legislation would do would be to require that you can only punish someone for a relatively short period of time. Then you can hold them in solitary confinement if there's substantial evidence that they pose some sort of threat to security. You have to make that finding. You can't just lock them up without it, and there's due process involved. So the first point I want to make is it doesn't force DOC to put dangerous people in the general population. It just forces them to make that determination. Solitary confinement is too harmful to use when it's not necessary, and to use any longer than it's necessary. The legislation requires that prisoners who are in segregation be given some rehabilitation as a pathway out. Am I 3 minutes old? Well, I'm going to let the rest of the members of my panel speak to
You feel free to submit written testimony as well. Thank you.
Thank you.
Good afternoon, and thank you for having me here today. My name is Sarah Sullivan. I'm with the Area Institute of Justice. We work with corrections agencies all over the country, the state prison systems and local jail systems, who want to reduce their use of restricted housing as a steel closet. Just kind of a disclaimer, I can't speak to what's happening exactly here in Massachusetts, as I'm not working with the department here, but I can speak to the national landscape. So Vera's work has been part of a national movement to rethink the use of restrictive housing. The conditions people are subjected to in these settings now regularly attract the attention of journalists, advocates, family members, and public officials. Today, there's a chorus of opposition that stretches far beyond advocates and includes the federal government, state policymakers, and correction officials, the U.S. Department of Justice, National Institute of Justice, and the two national professional organizations that represent correctional directors and correction staff across the country have all called for and passed new standards to reduce restrictive housing. And corrections agencies throughout the country are making reforms to this practice as well. A growing number of correctional leaders are moving away from the use of this in favor of more humane and effective strategies to achieve safe facilities for staff and the people incarcerated. The reason all of these places are reforming is because of the potential harms for people who are housed there, but also for the potential harms of the staff who work in these units as well. And at an institutional level, restrictive housing is extremely resource intensive, while research provides no conclusive evidence that it makes facilities or communities safer. And lastly, the impact on the community. While people are in restrictive housing, they typically do not get access to essential services that are needed to help them be successful when they return to the community. Systems have been successful at reducing the number of people going into restrictive housing and how long they stay there. Many officials will say that if you can reduce the use of this practice without negatively impacting safety in their institutions, it's a win. But systems have gone above that. There are systems that have also increased safety in their institutions at the same time reducing the use of restrictive housing. And there's also a fiscal component. Restrictive housing units are extremely expensive to manage. By reducing the population of restrictive housing, a corrections department can divert those resources to things that can help people stay out of restrictive housing and be more successful when they return back to the community. Things such as cognitive behavioral programming, mental health treatment, access to reentry services. And it also increases the safety in our institutions and the communities. I'll end by saying reforming this practice is not easy. Jails and prisons are complex environments, and many forces are at play in changing their policies, practices, and cultures. Corrections staff have become very reliant on this practice and has become a part of the institutional culture, as well as antiquated record systems, making it difficult to assess how restricted housing is used. Corrections agencies need support in order for these kind of reforms to be successful.
Thank you. Representative.
Thank you, Representative Cronin and Senator Brownsberger. Good afternoon. My name is Zachary Hyten. I'm the legal director of the ACLU of Maine. It is an honor to be able to visit you here in Massachusetts today. I received legal training here in Massachusetts at Boston College Law School, the finest law school here in Newton, Massachusetts. And it's always nice to be back to visit. I did more, though, than just simply travel down from Maine today to visit Massachusetts. I'm actually also a time traveler. I'm here to visit you today from the future, because Maine is now 6 years into its effort to reform the use of solitary confinement. And that effort began approximately 9 years ago when the Massachusetts legislature was considering legislation similar to what you're considering today, that would put some oversight, data collection, some meaningful restrictions on the use of solitary confinement in the Maine state prison system. At the time, there were predictions that are probably very similar to some of the predictions that you're going to hear, or maybe that you already have heard, that solitary confinement is necessary to have an orderly operating prison, that it's a critical tool for maintaining order, that there are no other ways for meaningfully punishing prisoners who violate laws other than subjecting them to long-term isolation. And that without long-term isolation, without solitary confinement, prisoners and staff, their health and their lives will be at risk. So now, 6 years into Maine's reform effort, Maine has reduced its use of solitary confinement by approximately 90%. There were around 100 people in the Maine State Prison Special Management Unit in 2010. And today there are approximately 11 people. That fluctuates anywhere between 10 and 15 from week to week. Significant reduction over the past 6 years. And yet, the prison is safer than it's ever been. prisoners. Medical visits are down, visits to the emergency room are down. All of this has been accomplished while ensuring that the prison is a more humane environment, and that prisoners with serious mental illness don't have those illnesses exacerbated by long-term isolation. And what is achievable in Maine is surely achievable here in the Commonwealth of Massachusetts. So I commend to you this undertaking of imposing some serious limits, restrictions, oversight, data collection on the use of solitary confinement. And I hope that you have as much success with it here in Massachusetts as we have in Maine. Happy to take any questions.
Thank you.
Hi, thanks for having me. My name's Noel LaRoe. It was my privilege to have been employed by the Massachusetts Department of Correction for 37 years. Beginning in 1974 as a caseworker, performing various administrative duties after that, the last of which was as unit administrator to the Secure Treatment Program, which is located in the Susan Master Correctional Center. Started with that in February of 2008 when the program opened, and retired, thankfully, in April of 2011. The program was tasked with taking inmates from the DDU who had been diagnosed with a major mental illness. They were considered to be the most difficult and disruptive inmates in the entire system. I appear before you today as neither an inmate advocate nor as an adversary in the Department of Correction. I have and always will respect and admire the men and women who are employed by the DOC and the courage and dedication they display on a daily basis. I simply oppose the practice of sentencing inmates to long terms of isolation, since I've seen their effects firsthand. When we took these guys in, starting in 2008 from the DDU, they were a mess. And just about any way you want to describe it. Traumatized, they were self-destructive, destructive, hostile, withdrawn, unkempt, filthy. A couple of them look like they just came out of a W camp. That's when I started forming the idea that maybe long-term isolation is not in the public interest. It does not enhance public safety or institutional safety. If anything, I think it's a detriment to both. And it's also costly and it burdens the taxpayer. Problem is, what do we do with violent and disruptive inmates? And having committed serious offenses while incarcerated, many of them felonies, they require a substantial period of time in segregation, and they must be removed from the general population in order to protect staff and inmates. Most inmates just want to do their time and go home. They need protection too, and to maintain institutional order. Routine disciplinary procedures, reclassification to higher custody, and outside court action could all be initiated. And rather than sentence an inmate to as many as 10 years in isolation, however, the inmate should remain in segregation, in my view, until it's determined via administrative review that the inmate's behavior, attitude, and program participation have improved to the point where he can be released to an open population and monitored closely. This is not a short-term process or a quick fix. Depending upon the severity of the offense leading to segregation, this would occur only after a substantial period of positive adjustment. It's important to keep in mind that most of these inmates will be released to an open population and to the community. It's better to give them a pathway out than to leave them in. Thanks for your time.
Thank you very much. Any questions? Any questions? Hearing none, thank you.
I'd actually like to hear a lot more from all of you, and I don't know if I have time to do it. I'm not going to keep everybody waiting, but I want to make sure that you reach my office and we were able to follow up with this conversation. Sure.
Councilor Devaney? Councilor, I just noticed on your sheet, The one bill that is being heard today is Senate Bill 819. I noticed that you have something on expungement. Those bills were heard on June 5th, but I'd be very happy to sit down and discuss them with you, but we're going to limit today's testimony to the bills that are on here today.
Thank you for this opportunity. Today I'm here to speak as a governor's counsel for 18 years to give you my experience on mandatory minimum sentencing related to drug offenses. When minimum mandatory sentences became part of our law, legislators thought they sounded like a good idea, but we have seen the injustices caused by minimum mandatory sentences. Judges are appointed to exercise discretion that is guided by law. To cripple that discretion is an abuse of logic and common sense. The time has come to let judges do their job. I'm here to support Senator Cream, Senate 819 in particular, and House Bill 741. If this legislation takes away all discretion of the judge has to follow the rule of law. You can't put the toothpaste back in the tube. By that I mean, you can't go back and change this one-size-fits-all legislation, which has affected so many people unjustly. But you can appeal it now to let judges do their job. Minimum mandate is nothing, sentencing is nothing new, but the most recent legislation passed years seems to be the most egregious. I will give you one example of minimum mandatory sentencing. 3 years ago, the Governor's Council had a man before us seeking a pardon. He was 57 years old. When he was 17 years old, he was on his way to school. An older friend, 22 years old, stopped him and asked him if he would do a favor to sell 5 bags of marijuana at school. This 17-year-old was an average kid, never involved in criminal activities. He was naive and wanted to please his 22-year-old friend. He went to school, sold 1 bag, and when he tried to sell the second bag, that student reported him to the principal. The principal found the other bags in his locker. In those days, the penalty was 5 years. Now it's 2 years. I can only imagine the judge who this young man appeared before. This judge had no discretion, no options, had to follow the law, had to put away this young man who made the most foolish mistake in his life. His youth was taken, no high school, dances, prom, sports, maybe a scholarship, no college. He came out and got a job as a custodian at a private school that is now closed. He married, had children, was a respected person in the community, volunteering and coaching. Now he's seeking a pardon after nearly 40 years. Yes, we voted to pardon, but where does he go at 57 years old? Even if he didn't have the baggage of being imprisoned. I ask you to vote judiciary, not legislatively. Don't take the discretion away from the judge. Let judges do their job. And I thank you for your consideration. I have other bills that I'm supporting. House Bill 2312, 2248, 2309. But I know I don't have time to talk on all of them, so perhaps I'll put that in writing. But I thank you for all your consideration. Thank you for allowing me to speak.
Daniel Mulhern. Daniel Mulhern. Oh, there you go.
Mr. Madam Chair, my name is Daniel Mulhern. I am the Director of Public Safety for Mayor Walsh in the City of Boston. And on behalf of Mayor Walsh, I'm here to speak today regarding sentencing reform. Mayor greatly appreciates the efforts of this committee and the timely work on this needed reform and reinvestment strategy in the final. Since becoming mayor, Mayor Walsh has dedicated resources to providing individuals with access to diversion and reentry programs that have proven to reduce recidivism and give men and women a path to success. He and his administration have worked tirelessly to ensure Boston is providing ample resources to support and lift people up and unlock them out. These programs include, but are not limited to, Operation Exit, Ethic, and Professional Pathways. They provide opportunities for at-risk residents, build a criminal background by providing the knowledge and skill required for entry into the apprenticeship programs. Through career readiness and occupational skills, these intensive programs assist with hands-on learning experiences and peer-to-peer mentorship to prepare participants for good careers. The mayor has also taken significant steps to coordinate across cabinets and departments to ensure accountability and impact. These include consistent gatherings of a safe city hall meeting and meetings with juvenile partners. He has created the first-time Office of Recovery of Returning Citizens and Recovery Services, both the first of their kind in the city of Boston, to address this increasing opioid addiction problem that's flooding our criminal justice system. The above illustrates the mayor's work and commitment to a justice and service reinvestment strategy, given that our criminal justice system has adopted challenges that are far beyond its original intent. Our police department is currently overwhelmed with the important issues of mental health and addiction, and our prosecutors were all overwhelmed with these caseloads. Similarly, our departments of supervision, probation, and parole are equally overburdened. As a conversation on sentencing reform continues to gain momentum, we must improve real alternatives to incarceration for our residents battling addiction. These alternatives must include the increase in long-term treatment beds and significant funding and resources dedicated to those. The mayor applauds the recommendations set forth by Governor Baker, President Rosenberg, Speaker O'Neill, and Chief Justice Gans to create a pretrial services program and provide incentives for good conduct and completion of educational and anti-recidivism programs. In addition, we would like to encourage the legislature to do a thoughtful review of drug classification. Lastly, Mayor Walsh strongly supports a consistent diversion program to treat nonviolent drug offenders that would benefit from recovery services prior to arraignment. And as you consider those reforms and the challenges of this afflicted population, allowing judicial discretion in certain circumstances regarding minimum mandatory penalties before incarceration may reduce or avoid the advancement hurdles that follow. Much work is needed by law enforcement partners and advocates and members of this committee, but we thank you for the opportunity to talk to your thoughts.
Thank you very much, and thank you for sticking to the clock. Any questions? No questions? Thank you very much. Could we please have Jim Pingeon and Phil Castle from Business Legal Service?
Good afternoon, everyone. My name is Jim Pingeon. I'm the litigation director at Business Legal Services, and I'm here on behalf of Leslie Walker, the director of my office, who is on the CSG working group and couldn't be here today. Business Legal Services is pleased to support the recommendations of the CSG group that are incorporated in page 74, and I'll comment just on a couple of parts of that bill. First, the provisions that incentivize increased participation in rehabilitation programs by raising the amounts of good time that prisoners can receive for participation in programs from 5 days to 7.5, and then raises the monthly cap from 10 days to 15 days. In addition, the bill provides for something new called completion credits, which allow prisoners to be given up to 80 days for completion of particular programs designated by the commissioner. These completion programs would only come off the parole eligibility date, not the maximum date. And if the prisoner were not paroled in the ordinary course, there would be non-discretionary parole at the date contributed using the completion credits. All of this sounds like a lot of good time, but it's much less than what the Commonwealth used to authorize in the previous sentencing days, when every prisoner who walked in the door automatically had more than 40% of the sentence subtracted. There's an overall cap of 35% of the sentence, which is in line with what other states do. The second part of the bill that we think is important is the requirement that the parole board and the Department of Correction collaborate in figuring out what the person's needs are and what programs he should participate in. As has been said before, there's now a problem where people come before the parole board call compliance credits for people who do well on parole, who abide by the conditions of parole, that they can get time taken off their parole supervision period, and this would allow parole officers to focus on people who really need to be focused on, and not the people who are doing well on parole and really deserve to have their supervision ended early. Thank you very much.
Good afternoon. I'm Phil Castle, I'm the Executive Director of Mental
Advisors Committee, we're a state agency that provides legal and policy advocacy for persons with mental health challenges throughout the Commonwealth. I'm here to speak in support of age 74. And also, in so doing, make reference to support that we also give to the number of bills that would address solitary confinement, which I want to enumerate now in the interest of time, but we'll have to support specifically about in written testimony. It's not very controversial to say that jails and prisons are our largest mental health facilities. For that, persons with mental illness are disproportionately impacted by the criminal justice system, particularly those of color. Reducing the jail and prison population in general will address what is commonly come to be known as the criminalization of mental illness. And age 74 will take steps in that direction for the reasons you said. I asked the committee to keep one further in mind in its deliberations over this bill, and that is that people with mental health challenges are perhaps the most vulnerable and least culpable of those in our criminal justice or our prison population. But not only are they disproportionately placed in jails and prisons, they're disproportionately damaged while they're there. MHLC, in collaboration with PLS, has looked very closely recently into how certain jails operate in their disciplinary systems, particularly with respect to those with mental illness. In many cases in which we've seen, prisoners with mental health challenges or serious mental illness have been sent to segregation cells as punishment for 30 days. With no consideration of the impact of their mental illness on their level of culpability or the appropriate sanction. They often act out while they're in these segregation or solitary confinement cells, and they get new tickets, which pile up to the extent that they are often in segregation there for years. And while they're at it, they're charged with new crimes. You're going to hear from clinicians, I understand, we're going to talk more extensively about the damage that they suffer. I litigated a case for a lengthy period of time. I had calls almost daily from prisoners who spoke with tremendous anguish about their experience in solitary confinement for prolonged periods. These prisoners' testimony to me is very consistent with what we hear from these clinicians. The SJC credited the expert testimony to the effect that we produced in that case, that solitary confinement not only creates damage, it creates damage that is permanent and irreversible at times. So the solitary bills will provide impetus for changing institutional cultures, and hopefully making them finish up like they are in Maine. But in the meantime, we need to reduce the numbers that are exposed to these cultures. It's practical and moral.
Thank you very much. Any questions? Questions? Hearing none. Thanks very much. Laurie Kirsch.
Hello, my name is Laura Tenshant, and I am the coordinator of the Mass Incarceration Working Group of the First Parish Unitarian Universalist of Arlington. I know that not all of you know me or us, but I just want to say we are a group that's been working for more than 4 years. We've had a formative March with about 300 people participating. Senator Grimes never spoke, which we were very grateful. We've got 800 people on the list. And I really want to speak about this theme of data that has been coming up over and over and over again. One of the things
if we could just try and figure out what's going on specifically here in Massachusetts related to the national patterns. And time and again, we have done that with the nobody knows, nobody's collecting this data. I've heard this many times during the testimonies, I'm sure you have too. And we were very relieved when the CSG report recommended collecting systematic collective data, including on racial and ethnic disparities, collecting it, analyzing it, and sharing it, and concerned when it did not show in the text of H74, which we basically support as we do many, a whole set of other bills that I think add up to a well-balanced meal, to use the image of this historian. People sometimes say that collecting data is expensive, and it is, but it's more expensive not to have it. It's more expensive not to know what's going on. Not to be able, without data, we can't evaluate the effectiveness of various interventions or programs, and we can't really understand where the racial and ethnic disparities come from, where we need to target interventions or whether those interventions are successful. As has been alluded to earlier, there is a fraying of trust in the fairness of our government, broadly speaking nowadays, and an effective, healthy democracy requires that basic trust that government is good and government is functional and is fair. And too many people of many different racial backgrounds are coming to the conclusion that our justice system is actually an injustice system. We really need, my group thinks, to collect this data. We do have and use it to guide comprehensive criminal justice reform. We do have a mass incarceration crisis in Massachusetts. We're better than much of the country, but we're terrible compared to other wealthy democracies, and we're terrible for many individuals and for their families, the people who love them, the people who depend on them. Please, I'm urging you to this comprehensive data collection, sharing, and comprehensive criminal justice reform. Thank you.
Thank you. Any questions? Any questions? Thank you. Good. Foreman, Steve Casella, and Michael Cuddy.
They had to go.
Okay. Representative Tyler. Alice Sach, Nancy Reed Stockwell.
It's strong enough to do this. Could you speak into the mic, please? I am going to speak about a dangerous major public safety issue. I am the mother of Stephen Reed. I am barely 5 feet tall and 75 years old, but I am determined and compassionate in getting this bill number 849 and Senate Bill 784 passed. Please be advised, the verdict of not guilty or murder by reason of insanity is a dangerous major public safety issue. The murderer will not have a Corey record. The murderer will be able to be released into the general population, will be able to work in children's daycare, preschool, school systems, classrooms, cafeterias, school buses, hospitals, nursing homes, as home health aides, and live in senior and public housing if no Corey record exists. Please support these bills stated above. The citizens of Massachusetts are angry, astounded, in disbelief, and appalled when informed that murderers can care for and be near their families. My son, Stephen Reed, was the victim of an extreme atrocity, stabbed over 130 times with astounding violence.
cruelty. Every organ of his body was stabbed. After sitting and listening to the testimony and trial for his murder, the murderer was found not guilty of murder by reason of insanity. I was not able to make a victim impact statement because the murderer was found not guilty. All murderers of this verdict presently will not have a quarry for criminal offender record information. Only the murder of my son did I find out about his origin. This is a dangerous, major public safety issue. The danger to the public and their families is real, and it's happening. Being found not guilty of murder by insane does not address the murder being a danger to the public. Oh, it's killing me. I'm sorry. All of a sudden it's started coming. The murder being a danger to the public because they do not have a criminal record. The murderer can be released eventually. I would say to the citizens of Massachusetts, beware, danger, and to you, the Judicial Committee, public safety for your family and the family of all Massachusetts citizens should be a priority. Thank you for listening. Mother of Stephen Reed.
Thank you very much for sharing your very private story. It really matters, and I know it's difficult to do so, and appreciate you doing that with us today. Thank you.
Thank you for your time today. My name is Nancy Reed Stockwell. I'm the sister of Stephen Reed. My brother was a loving, innocent man and was brutally murdered. Unfortunately, we were unable to protect him from that harm, but we are here now trying to change the law with his memory. His murder trial taught us many things, some things we really didn't need to know, such as the severity of his injuries. We learned that every organ in his body was punctured by a very long, serrated knife. He begged her to stop stabbing him. I'm still not sure how my mother made it through that testimony. We also learned that his killer had been mentally ill for approximately 20 years, going up and down the East Coast wreaking havoc. Her children were removed from her custody because of her illness. She failed to take her medication on numerous occasions, so many times that her medical providers recommended her Rogers petition. Also during that trial, the expert psychiatrist opined that, in hindsight, the filing of a Rogers petition probably would have prevented that murder. Well, that petition was never filed. My brother's murderer is now in the care of that same mental health agency that failed to procure the Rogers petition. And so our family does not feel reassured by this fact. When we attended the murderer's first competency hearing, we were told that she had already taken day trips out into the general public. And to date, we still don't know her whereabouts. We're simply told that, quote unquote, she has rights. What about the rights of all the innocent, law-abiding citizens that live or travel to the vicinity where she may be? Or a potential employer that will not be aware of her past? The worst part of this whole situation is that the verdict did not contain the word guilty, and she has no criminal record. But she should have a criminal record because there is no doubt that this murder took place. So I ask you, how do you recommend that we keep our families safe? Please do not leave innocent people in the dark any longer. The next person injured or killed could be your loved one, and then you will be plagued with the fact of, or the thought of, how can we keep this from happening to someone else? This is a major public safety issue. The general public is astounded to know that a mentally ill murderer could end up someday maybe caring for someone they love in any type of work environment. So please change this law and protect the people of the Commonwealth.
Thank you very, very much. Does anyone have any questions?
Thank you.
Thank you. Martin Murphy.
Good afternoon. Vice Chairwoman Cronin, Senate Chairman Brownsberger, and members of the Joint Committee on the Judiciary. My name is Marty Newton, and I'm here today on behalf of the Boston Bar Association. I've spent the last 30 years working in the criminal justice system on both sides of the aisle, defending and prosecuting nearly every conduct case, from drug driving to murder, including many drug cases. I'm also the co-chair, along with former BBA President Kathy Wyman, of the Criminal Justice Working Group that we expect will soon be making recommendations on a broad range of reforms to the criminal justice system. The BBA will speak broadly on those issues once the report is adopted, but for today, I will focus my remarks on mandatory minimums, which the BBA has spoken out against today. In the time permitted, please permit me to make 4 brief points. First, mandatory minimum sentences fail every test by which we should measure the strength of our justice. In place of proportionality, the notion that the punishment should fit the crime, they offer one-size-fits-all justice. They frequently require judges to impose sentences longer than those judges believe are necessary or just, leading to the phenomenon of end-of-day sentences. And these overly long sentences, in turn, delay the possibility of reintegration, restrict access to the very programs that have been shown to help make that process a success, and often turn prisoners back to the street without help to find employment, or housing, or support, or supervision. Second, mandatory sentences effectively turn over the reins of the criminal justice system to prosecutors and strip judges of their power to impose the kind of individualized sentences that would, in fact, make the punishment fit the crime. Mandatory sentences are mandatory only when prosecutors want them. In practice, prosecutors often use them as bargaining chips in the plea bargaining process. When that happens, when prosecutors use the threat of mandatory sentences to drive the process, we lose transparency and we lose accountability. And the result is justice behind closed doors, with the prosecutor effectively choosing both charge and sentence. Point number 3. The evidence shows that mandatory minimum sentences help drive one of the most deeply disturbing aspects of our state's criminal justice system, the problem of racial disparity. We may have one of the lowest incarceration rates in the nation, but our criminal justice system's record on race is nothing to be proud of. A study released last year showed that our rate of disparity in the rate of sentences between black and white residents was the 13th highest in the country. And for Hispanic defendants, we rank number 1 in the United States. Mandatory minimum sentences help drive that rate of disparity. 4 out of every 4 defendants sentenced to mandatory minimums are defendants of color. I'll wrap up finally by saying that we think there's much good in the CSQ report. We congratulate the members of the House and Senate who worked so hard on it. But we believe that the time for more comprehensive criminal justice, including a radical look at the revision of mandatory minimum sentences, is now. Thank you very much.
Thank you, Mr. Murphy. Do you know when you anticipate your report to be complete?
I would say we have about 30 days.
Okay. Thank you. We'll look forward to seeing that hearing for you.
Thank you very much for your time.
Any questions?
Your organization represents both prosecutor and defense attorneys, is that right?
Yes, it is. We do represent, we do have members certainly from all sides. I wouldn't necessarily say that every member, including our prosecutor members, agree with every position we take. I want to make that.
You two
We're very happy to have folks from every DA's office as members, but our policy-making process is driven by the leadership of the organization, which of course is subject to the folks in the groups.
So I'm just curious, I mean, you must, given the internal, lack of total consensus, right, I would assume was there in your membership. I imagine the Bar Association in many ways faces a similar tensions that the legislature does on this. How did you arrive at this position? If my understanding is right, the Bar Association has held for quite some time.
Yes. And you know, I think that that's a position that we advance that's been developed over time. I think when the Bar Association makes policy, it tries to do it in an independent, objective, evidence-based way. It really isn't tied to particular kinds of ideology. And we all draw on the experience we have. And there are many people in our organization who spent many years as I did as prosecutors. But I think as a whole, we have a certain perspective where we do our best to take account of the views that everyone has. But our policy positions, we hope, are driven by what the data shows. And we believe the data shows that mandatory minimum sentences do not effectively prevent or deter crime, and instead make things worse for many defendants' families, for many communities, particularly communities of color, and are costly to taxpayers without any significant cost of benefit. Thank you.
Thank you very much. Any further questions? Good to go. Could we have members of the Mass Bar, please? Thank you. Yeah.
Good afternoon, my name is Bob Connett, and I have been pastor of the National Bar Association. I'm also proud to say, and have proud to say, first speaker of the National Bar Association. I want to start here by saying the National Bar Association is a long-standing commitment for effective and efficient criminal justice system as possible. But I need to get back. I'm going to deviate from this speech for one reason. You heard testimony today with regards to mandatory minimums and how defendants come forward and ask for it to be broken down. And then after they're broken down, people go forward and try a case and say they can do it fine. And they work it out. I will tell you, 27 years of practice in criminal law, I have not seen that happen once. I have not seen minimum mandatory crime be dropped down to a lesser crime if you're allowed to bring to trial. It does not happen. I challenge anybody to bring me forward an attorney that says, in their experience in the criminal world, in the criminal justice world, they've seen that happen. It does not. You have to beg the grovel to get anything reduced to minimum mandatory. You do. It does not happen. At times, so coming to court and say, listen, I'm going to drop it down. No, it does not happen that way. That is a myth. And I'm deviating from my speech because I heard it be stated. And I've been practicing for 27 years. I've never seen that happen. So now I'm going to go back to my speech. The NBA supports elimination of mandatory minimum sentences for drug-related crimes, especially today when the Commonwealth is grappling with the terrible drug epidemic. Mandatory minimums are not only part of the problem, they are getting in the way of the solution. By removing any discretion for meaningful rehabilitation and treatment, mandatory minimums contribute to the high recidivism rate found in many drug offenses, effectively sentencing addicts to life in installment plan. It is essential for public safety that the inmates of the mandatory minimum sentences be given an opportunity for parole. Parole supervision has been demonstrated to reduce the likelihood of recidivism, which means less crime than neighborhoods. Parole is less expensive than incarceration, which costs as much as $48,000 per person per year in this state prison. I will say I also have a role general counsel for county jails. Not having parole opportunities for drug offenders not only wastes taxpayers' money, it increases the likelihood of crime and additional victims. Change isn't easy. For generations, politics have been driven by sensational editorials. The loud voice of certain law enforcement officials call harsh punishments for a broad range of offenders, and the simplicity of putting more and more people in prisons and jails. And please hear this. For matters they cannot prove in a court, you heard testimony before, that we engage with it when we drop the minimum mandatory sentences based on what we hear outside, based on the information police officers get outside, nothing they have to prove in court.
I've testified before this committee in the past, and they indicated that it's intel on the street. I would close by saying this: we must learn from our past. DA should not prosecute a sentence, and also, as an attorney, as a probation officer, as an investigative DA, and also as a father who's had to deal with his own family, I will tell you, minimum incomes do not work. Thank you.
Good afternoon, I'm Peter Elkin, and I was listening to District Attorney Conley, and he was advocating the idea that let legislatures do their job, set the parameters, and limit the unfettered discretion of judges. But the path he advocates still gives unfettered discretion to get around mandatories. It just substituted, it gives the discretion to the prosecutors. In other words, the prosecutor becomes the sentencer, the prosecutor becomes the decider. We go to the prosecutor as attorneys. We don't go to the judge, these hands are tied, it's mandatory. We go to the prosecutor, we plead, and we gravel. It's an adversarial, it's so odd that an adversarial system, two sides against each other, and one gets to be the decider. It's as if there's a boxing match where one of the boxers also gets to be the referee and decide the outcome. Instead of going to a neutral magistrate, and therefore we really get no consistency at all. The Massachusetts Bar Association would basically states that harsher mandatory sentences are ironically soft on crime. They may be tough on particular individuals, but they are soft on crime. They operate to make the public less safe. Every bit of legitimate, evidence-based research over the past several decades points to more effective ways of combating the drug epidemic rather than squander drug-fighting dollars on less effective methods. The less effective method of jail. If we learn nothing else, it's that we can't arrest our way out of the problem. It's not like we ever tried. We did. And this modern drug war started. The Nixon administration started in the early 1970s. That's about 45 years. And we would probably see some result by now. However, drugs are cheaper, more available, as we've heard people say, and more lethal than ever. So why do we keep doing the same old, and talk like that's going to be the effective thing? One of the strongest arguments is that although crime is down everywhere, the states that have followed the evidence-based research and repealed mandatory minimum sentencing have seen the most extraordinary crime drops. And Senator Greenwood, I think, was right on the money when she said that she noted that a number of the most conservative, tough-on-crime states with previous reputations for harsh sentencing moved further than Massachusetts and reduced or eliminated mandatory sentences, some that you'd never expect. Texas, Mississippi, Georgia, North Carolina, South Carolina, Kentucky. It frees up money for real recidivism producing programs. And I just want to conclude with the hypothetical example that I give. It's the best example I think I can argue that if we were to give if somebody to get a mandatory sentence, it costs about $750,000 to put somebody in jail for 12 years. If I said to any of you, I'm going to give you $750,000 to fight crime, put on your thinking cap, be creative. What do you want to do? More drug prevention for thousands, drug rehabilitation for hundreds? Or would you say, no, I'm going to take my $750,000 and I'm going to put that girlfriend or welfare mother or teenager who got paid $50 by some drug dealer, I'm going to take that money, I'm going to put that one person in the cell. That's what I'm doing with my money. Thank you.
Good afternoon, Madam Chair, Mr. Chairman, members of the committee. My name is Lee Gartenberg. I've been the Director of Inmate Legal Services for the Middlesex Sheriff's Office since 1982, so after going to law school, I've been in jail for 35 years, with the exception of a stint that I spent as a member of the Massachusetts Parole Board. I want to be clear, I'm speaking on behalf of the NBA and not the Middlesex Sheriff's Office, despite my long history at the MSO. I'm going to give you a perspective on mandatory sentencing that nobody else has given yet, and that is from within the correctional facility. Those of you who practice criminal law or are familiar with the criminal statutes, you know what the minimum mandatory is that boilerplate language which says this cannot happen, this cannot happen, this cannot happen, this cannot not happen if somebody's serving a minimum mandatory sentence until they've served the minimum mandatory term. What this does is it ties the hands of corrections officials who now have some pretty sophisticated assessment tools like the LSCMI. And when somebody is intaked and they do an assessment, the assessment often recommends various kinds of programming, possibly a classification path. And lo and behold, some of that boilerplate language prevents some of it from happening. So some of the things that corrections officials determine are the best things to do as part of a classification plan can't happen. So one of the things that would be desirable and the NBA would support is mitigation not only of the mandatory minimum provisions, but the way it affects the execution of sentences to limit the discretion to set up treatment programs. This is especially important for successful reentry, and especially when you consider the opioid crisis. Because one of the things that happens with minimum mandatory sentences is when somebody wraps up their sentence, if you're restricted from classifying them to a gradual reentry program, then when they leave prison, they're going from a very controlled situation to life on the street with an abrupt shock. Now, even before the current opioid crisis, all the years I was working in corrections, we hear these sad stories about people who were drug addicts, who wrapped up their sentence, went back to using the same level of drugs they used before and overdosed. And that was before the presence of fentanyl and carfentanil. So I think any statutory scheme that encourages flexibility in setting up reentry programs, both by corrections officials and the parole board and the Office of Commissioner of Probation, I think also would help give us some more tools in addressing the opioid crisis. Just very briefly, I want to address one other point, which is Senate Bill 803, which gives judges flexibility when somebody appears before the court with a suspended sentence on a probation violation. Senator Brandenburger knows I'm big on this. The so-called Holmgren case doesn't give judges flexibility. When somebody has a suspended sentence and they violate probation, the judge has to impose a sentence of either the full suspended sentence or to reprobate the person. We think, consistent with what other people have said about the desirability of judicial discretion, judges should have more discretion in this area also. Thank you very much.
Thank you. Any questions? No questions. Thank you very much. Tom Hodgson. Joshua Wernberg. Okay, do we have,
we were on the list also, passion release.
okay, I just want to make sure we have Benjamin Schlechter, Joshua Warner, okay, so yeah, and Josephine Henderson?
Yes.
Terrific.
Thank you, Chair Cronin, Chair Brownsburg, members of the committee for your time. My name is Joel Thompson. I'm a staff attorney at Business and Legal Services, and we are here, all of us, in support of medical placement of terminally ill and incapacitated prisoners. We appreciate this committee's leadership, led by Chair Cronin's bill, H. 3494, Senator James' bill, Senate 874. I don't want to get into mechanics and differences in how this thing should be worked out. We are just here to support the notion of medical placement and to state the need once again for a law for Massachusetts to join the rest of the country in having some ability to get dying and incapacitated prisoners out. It's not a sweeping proposal, some of the other ones before you today, but it's no less important. Providing care, complex medical care to people in this condition in a prison facility is just not possible. All right, it is hard, it is expensive. It is logistically challenging both for medical staff and for correctional staff. And I come back to you, as I did 2 years ago and 2 It's a client at the BLS whose palliative care plan prescribed by the gynecologist will not be given to them because of feasibility and logistical issues in the prison. And that's going to be for this 7 days. It's the family member scrambling to get through the multiple layers of approval, to get a visit, to find out where the dying relative is and get that visit in the hospital. Visit which won't even be private because there will be 2 correctional officers on hand. It's the provider who, in a quiet moment, not for attribution, will say, it stinks to have to work in a setting where you know you can't provide the care the way it ought to be done. And to send someone out to the ER over and over again because you fear this is it, and then they stabilize and they come back. There's considerable financial cost to that, and frankly, there's also an emotional cost for everyone involved and everyone who works in that setting. So the need is there. The need won't go away. The number of older prisoners is rising, both in relative terms with a declining overall population, but also in absolute terms, the number of prisoners 15 or more is going up. We need to give the latitude to correctional professionals and to medical providers to do the right thing and get these people to a more suitable place. And then we can reuse those resources that we save on this end and put them to better use somewhere else in our criminal justice system. To better illustrate this point, I have for you a medical resident in internal medicine who's worked with prisoners, an oncologist from the Beth Israel who has his own work with dying prisoners, and a lawyer who came face to face with what happens when we don't have such a long place. It's all in the 10 minutes.
Hi, I'm Dr. Joe Harrison-Cross. I'm a resident physician in Mass General with American Internal Medicine Program. And I'm representing testimony here on behalf of the Harvard Medical School's Crimson Care Collaborative and National Street Journal. And this is a student-faculty clinic that was founded in 2014 between Harvard Medical School students and attending physicians in collaboration with the National Street Jail and an assistant clinic there, which is located in Boston. And the 2 purposes are to educate healthcare professional students about providing healthcare for underserved and providing compassionate care for the incarcerated and detained. And as a resident, I actually work with medical students and mentor them and sort of the scene and clinic. So I've been doing that over the last year. And I will say that a lot of these patients in National Street Jail also bounce back to Mass General, so then as residents, we take care of the same patients who be able to see in the detained setting. So during the past 3 years, the clinic has seen innumerable patients who are significantly debilitated by severe chronic illnesses. You can imagine stroke patients, heart failure, cancer, there's a very long list. And I'm going to give you 2 patients that I'm familiar with as examples. And basically, in a minute, the point is that over time, we identified that the jail is significantly overwhelmed with working with their care, and thus that they're really not able to receive the quality of care that is necessary for a medical condition. And that has to do with the need for frequent medication administration, frequent nursing checks, vital signs, oxygen, and often also assistance, bathing, eating, and doing activities of daily living. So, 2 patients I'm familiar with. The first one is a 36-year-old man who was detained, undocumented, and he had really severe heart failure, temporal slides, ventricular failure, actually requiring a heart transplant, or he had a very terminal diagnosis. It was so bad that he was chronically short of breath, needed oxygen. And unfortunately, in National Street, they were unable to correctly identify when he was sort of falling off this cliff into decompensated heart failure. And so as a result, he had frequent admissions to the cardiac intensive care unit over the course of the year, severely ill, sort of bouncing back and forth between these long, complicated hospice stays, going back to an environment that was unable to provide for him, which is obviously costly to the system and very sort of dangerous for his health. And the second patient was someone who suffered a stroke. As you know, stroke is not identified rapidly. The patient will have sort of permanent side effects and residual complications. And this patient had a stroke, was transferred to the hospital, and then had moved to new debilitating ramifications, unable to move at all, and have to go back to medical school. So anyway, we believe that this bill we're discussing today will guide our state towards a small justice and compassion and healthcare equity that allow dying to individuals or minimal risk to society the opportunity for collective cleansing. Thank you very much.
My name is Ben Schlechter. I'm the Director of Innovation Oncology at Lincoln's Medical Center. I'm a medical oncologist. I specialize in genetic cancers, in particular pancreatic cancer, colorectal cancers. So fundamentally, as a medical system, as physicians, our obligation is to provide a standard of care to every patient, whether they're incarcerated or not. And the easiest way to understand the standard of care is doing what's right medically. So the standard of care for cancer patients, the right thing to do is to cure them when possible. And when not possible, provide them care when they're terminally ill, prolong their life, and keep their quality of life. From the time of help those patients, they'll help them die diabetically, help them die humanely. Unfortunately, where the standard of care for incarcerated patients is not being met in the Commonwealth of Massachusetts. For example, standard chemotherapy for GI malignancies involves a drug called 530 or so 5FU. It's an infusion that's given through a sturdy pump that a patient can give himself or herself for days or weeks. It's a sturdy pump, a long tube with sharp needle at the end of it, so we can't give those to patients in prison for obvious reasons. The drugs we give are also dangerous. Patients receiving chemotherapy risk of infection or bleeding. They can even die from these drugs. And I have patients with prison guards. I tell them it's unsafe for you to provide care at a prison. You can't be in that environment receiving chemotherapy. So the result is that these patients cannot be housed in the prison population. The result is that they're admitted to the medical centers of Boston and Pepper's weakness, where we give them chemotherapy, but we can't even provide a standard of care in that setting. Patients who are in prisons know when they are in the hospital, they have 2 guards present, and they are shackled to their bed. This results in decreased mobility. It results in decreased risk of blood clots, which can be fatal in cancer patients, bed sores, even on the elbows for their arms shackled, and not meeting the standard of care for these patients. The result is that we can't do what we need to. And prison infirmaries are not equipped to do this. Even community hospitals, and large community hospitals, like the Shadow Hospital, where I've seen 9 patients, are not equipped to care for these patients. Ultimately, I think it's clear that we need to do something, providing for a medical placement for our patients and further prison infirmary. Massachusetts leads medicine in the United States. We are the leaders in standard of care and advancing standard of care throughout. And I think it's important. It doesn't end in our patient-centered justice system. So I should consider these very seriously.
Thank you.
Good afternoon. My name is Joshua Warner. I'm an attorney. My office is in a town called Easton, Massachusetts. But nevertheless, I was asked to speak here today because I have the unfortunate task at this point in time to represent an individual who's actually in need of your services immediately. So let me start by saying, I represent a gentleman who did not handle his case initially. I think this matter on a pro bono basis, and he, back in 2012, stupidly committed two series of armed robberies. Not the best person in the entire world at that point in time. And in 2014, he pled guilty in the Fall River Superior Court, Bristol County Superior Court, received an 8 to 15-year sentence. Complicating that fact is that one of the charges was a mass armed robbery, which for those who don't know, carries with it a sentence, something we're all talking about here today, it was a mandatory sentence of 5 years to a minimum parole. He was sentenced and he went off. Approximately 30 days after he landed in state prison, as described in the medical records, he suffered a fall. It was unfortunately not recorded after he was at a southern facility, so one can presume whatever that was. But nevertheless, at the time he suffered the fall, people didn't realize was he was on blood thinners. He suffered a traumatic blow to the head. In fact, he suffered multiple traumatic blows to the head. And he landed himself at a Shadow Hospital where they performed any community activity which he would develop for that. And brain bleeding in his head. He was treated, he was then sent back. Ultimately, he did at the Boston Medical Center and received 2 more surgeries at that point in time. He now resides on show of physical medicine. He's totally incontinent. He wears a diaper. He's fed through a gastric tube in his stomach. He speaks in one word answers to questions. He occasionally will track and follow my directions, my questions, and other times he doesn't. To the credit of the prisoners who are there with him, they take turns taking care of him here because the medical staff are just overwhelmed. They don't have the ability to provide any rehabilitation services, or they have any period of time to actually change and clean up the diaper and give him a bed bath. So the other prisoners are giving up their time to come and take care of him. Why I'm here today is I filed a motion in the Florida Superior Court, called a motion revised and revoked. I asked the judge of the Superior Court to consider revoking the sentence and terminating it. The family has a medical placement for him outside of the hospital setting at the prison. He's not going to be involved in prison. The family is not going to be able to do any more crimes anymore. It's likely it's not going to change in a pre-vegetative state. It's a good plan. That motion revised and revoked was heard and argued before a justice in the Superior Court, who quite frankly almost begged the prosecutor at this point in time to agree to it. And the prosecutor did not. And ultimately, there is now no other remedy. This individual will receive either a reduction of the sentence or potential for early parole, because quite frankly, he doesn't wrap up his mandatory 5 sentences at the end of 2017, and because he has an 8-year sentence under the parole guidelines, which is not even services, work programs. The prison said, "You're not having a good time. He's lying on the bed." Compassionate release, I think, is an appropriate remedy for him to be considered for something like this. He's going to go up, his parents are going to take him, his mother and his sister come to my office continuously, asking what they can do. And what there's something that I don't have anything. So that's why we're here.
Thank you. I would just like to make a small request at this table. Would you be willing to submit your testimony in writing as well to the committee? That would be greatly appreciated. Anyone have any questions? Any questions? Thank you very much.
Thank you.
We have Superintendent Rich, Boston Police Department. Guy Clovis, please.
Thank you, Madam Chairwoman Curran, Mr. Chairman, members of the committee, thank you for the great work that you do on behalf of our citizenry, and thank you for your time today. I will be extraordinarily brief. I know there's a lot of good speakers here that want to say a lot of good things. I am here with the legislative agent for the Mass Correctional Officers Federated Union. The union is here and it was asked to oppose House Bill 2249, 2248, 3071, and 3585. Mostly the concern is with the segregation units. As some of the previous speakers have mentioned, we have a very progressive state when it comes to other states throughout the country, when it comes to segregation. And one thing that wasn't mentioned earlier is there is transparency, there is reporting, and there is policy and procedure for every single segregation unit and solitary confinement in Massachusetts. The office feels that this is a valuable tool in being able to keep safe and secure not only the offices, but other inmates as well. And it's also mentioned that many inmates ask for these segregation units for fear of their own well-being. It could be a rival gang member or a hit put out on them within prison. So we would ask the committee to at least talk to the DOC and members of the Mass Correctional Officers Union before they move forward on any of those bills. Thank you, Madam Chair.
Thank you. Any questions? All set. Thanks. Beth Cheney, Jorge Belize, and Susan Montagna. Guess they have to leave. Mary Dinowitz?
so we have the 3-minute rule. Tatum Pritchett.
Good afternoon, Chairperson and members of the committee. My name is Tatum Pritchard. I'm an attorney at Pritchard's Legal Services. Testifying in support of 2 bills, H719 and H721. I'll take them in reverse order. H721 is an act relative to ensuring all mental health services in state correctional facility. Bill that Ms. Ball spoke of briefly earlier today. H721 provides for DMH supervision of mental health care in the Department of Correction, including review of DOC contracts with vendors of mental health services and the setting of minimum standards for mental health care in prisons. It requires DMH to conduct regular audits of mental health care in each facility to ensure compliance with these standards. The DOC reports that 30% of all male prisoners and 70% of all female prisoners have open mental health cases, and the majority of them are prescribed psychotropic medication. Yet the DOC, which contracts out its medical and mental health care, lacks the expertise to craft and supervise a contract ensuring adequate treatment. The contractor, driven by financial incentive to reduce costs, underdiagnoses mental disorders, and limits access to clinicians, medications, and treatment modalities. Nowhere has this been more evident than at Bridgewater State Hospital. Doctors and clinicians employed by the DOC's medical contractor, the Massachusetts Partnership for Correctional Health Care, were using seclusion and 4-point restraints on Bridgewater patients at a rate more than 100 times higher than any other forensic hospital in the United States, and who will provide appropriate care. Fortunately, at Bridgewater, the DOC, at the direction of the flickr administration, hired a new contractor, but all other DOC prisoners still receive their mental health care from NCH. The primary mission of DMH is to ensure that all citizens of the Commonwealth with mental illness receive appropriate care. Accordingly, DMH is the appropriate body to oversee the provision of mental health services to prisoners. The Senate bill is an act to improve public safety by facilitating access to addiction services. This is a very simple but extremely important bill that requires all prisoners held in state and county correctional facilities to be screened for substance abuse history, and if they have such a history, be offered treatment upon request. According to recent information from the DOC, 75% of its population has a substance abuse need based on a standard Texas Christian University drug screening. At the same time, as we know from the Hernandez investigation, there's an extreme problem of drug use within facilities. This bill will ensure that appropriate care is ready and available for prisoners who need it to address these problems.
Thank you very much. Any questions? Thank you. Justin Brown.
Hi, thank you. I'm here today to represent an organization called Empower. We've been around for about 30 years. I myself have been diagnosed with a major mental illness, and our members are people who have been institutionalized in psychiatric institutions, who've been restrained and secluded in psychiatric institutions. I'm here to support H720, a bill that is to guarantee access for people like myself to inpatient care. But before I go on, I just want to say my heart went out to the mother and the sister who were here today. Their loss, is so grave. And we just have to remember that when the globe plasters, 20 5% of us who are murderers are folks like myself, we have to remember that when we look out across this room, 25% of us have sought some kind of therapy, have sought some kind of support around mental health challenges. It shouldn't be surprising that when that same standard is applied to murderers, that 25% of us fit there. I agree that we need to be held accountable, but what we don't need to be held accountable to is when we go to an ER, when we go and ask to be treated on an inpatient basis, when we're seeking care. H720 says we cannot be sent to the criminal justice system. What is happening is that we walk into Boston Medical Center, we say, we need help. We walk into a hospital and we're restrained, and then we fight, sort of against those restraints. Too often, we're charged with assault and battery. I'm not talking about murder or these kinds of things. I'm just talking about people who are trying to get care, who are charged with assault and battery in inpatient settings. Why send us to court? Why send us to the criminal justice system when we're here seeking care? And H720 simply says, give us treatment, don't send us to court as we come into the hospitals. Thank you.
Thank you very much. Any questions? No questions, please. Jesse White. I don't have any as a panel.
Thank you, Chair Ronson, Chair Cronin, and the committee. I really appreciate the opportunity to speak today in favor of House Bill 3585 and an act relative to intrusive cell procedures, sponsored by Representative Mary Keefe. I'm the staff attorney at Prisoners Legal Services that's dedicated full-time to responding to all prisoner complaints of excessive use of force, so I handle a lot of these incidents. Force must sometimes be used in prison to maintain institutional security. However, excessive use of force compromises public safety by undermining trust in corrections, causing trauma that creates barriers to successful reentry, and increasing institutional violence. This bill addresses several issues that I want to touch on. First, it requires the Commissioner to prohibit the use of certain kinetic impact weapons. Worcester County House of Correction uses such a weapon called the FM303, which is standard equipment during all of their planned cell entrances, planned uses of force. The FM303 is a gun that fires plastic projectiles that have metal pellets in the front. And it's the weapon that killed Victoria Snellgrove in 2004 after the Boston Red Sox victory. I work with a prisoner at Worcester County House of Correction who blocked his cell window after having a verbal disagreement with an officer. He was in a closed, locked cell and was not harming himself or anyone else. He did repeatedly refuse orders to come to his store to be handcuffed, so a team of officers in full SWAT gear first sprayed him with chemical agents and then shot him approximately 30 times with the FM303. He suffered welts and bleeding lacerations all over his body. I brought with me today a photograph of injuries suffered by another prisoner who was shot by the FM303 at the Worcester County House of Correction. You can see it does cause very serious puncture wounds.
What is the scale we're looking at?
These are puncture wounds that were suffered by a prisoner who was shot. This is a photo of his arm, and these are measurements. This is 1 inch, so the puncture wound is about a ½ an inch long, you can see here. And there are 3 kind of clustered in a row. I've got more pictures like this than you want to know about. It's awful. This bill, first of all, I just say no other facility in the state uses this weapon in this manner, and there's nothing unique about Worcester County that requires the use of this weapon this way. This bill, to that end, seeks to create baseline standards that would apply throughout the county and state systems. Right now, accidents and geography dictate whether a prisoner is subjected to egregious use of force practices. Essex County Correctional Facility, for example, uses dogs to bite prisoners routinely. Suffolk County Correctional Facility uses uniquely draconian planned use of force practices, including misuse of chemical agents and routine use of restraint chairs after there is no planned use of force. Finally, this bill would require that officers wear body cameras during command and spontaneous cell entries. There's widespread recognition of the importance of video recording of use of force incidents to increase accountability, prevent abuse, and ensure that there will be an accurate record of what occurred in these very serious incidents. So I think this is extraordinarily important. Thank you very much. Does anyone have any questions on this? No questions? Okay, thank you very much.
Wendy Glassman? Weissman? Is that it one? Julie Weiner and Sally Chen? Liz Natchez? And telephone services?
Good afternoon, and thank you for your patience with hearing all our testimonies today. So I just wanted to testify briefly in support of H825 and H966, which are about providing telephone service in the prisons. Just to give you some background, this isn't necessarily an issue that's as much in the public view as some of the others you've heard about today. The way this works in the correctional agencies contract with loan providers for this service, and generally the highest commission player gets the contract. And the commission is a percentage of the phone revenue that the provider pays back to the facility as a kickback. And the problem is that the cost of this kickback gets passed on to the consumers, which are the family members of, largely family members of the prisoners, although some prisoners use that they do have, they're lucky enough to have a prison job, they're very much involved in this funds to stay in touch with their family members. The result is that we get exorbitant prison telephone rates. It's essentially a monopoly. People pay $3 to $4 just to connect the call, and then a permanent rate in addition to that. This bill would ensure that the contracts are negotiated on the basis of getting the lowest rate possible rather than on the highest commission bid, and it would end the practice of these kickbacks going back to the facilities. There are 14 other states that have already done this, so it's not unprecedented. And the reason why this is so important, there are a couple of reasons. One is that the telephone is a lifeline for these families, not just because prison life is difficult and oftentimes the connection to the family is what keeps them positive and keeps them going, but also because family ties have been positively correlated with lower recidivism rates and more successful reentry. The stronger context they have in the community, the better prepared they are to be successful in the community when they reenter. So it's kind of common sense, but it's something that's often overlooked. But also the distance. Many of these families cannot get to these facilities to visit their loved ones. Many of them have disabilities or they're elderly. Children are in school and they can't go during visiting hours. So this is really, really important in terms of keeping families together and keeping those ties strong so that when they re-enter society, they're not isolated and disconnected. And then finally, the reason this is so timely also is because right now we have a little bit of a regulation problem in Massachusetts. Secures is one of the major companies nationally, but also has several contracts here in Massachusetts. And they've just decided that the Department of Telecommunications and Cable in Massachusetts no longer has jurisdiction over to regulate because they're an IP-enabled company. An IP-enabled company, Internet Protocol enabled, we don't have to get into it, but suffice to say, they no longer feel like they're subject to state regulation. And the same would apply to the other phone provider, which is Global Telling, GTI, and the Federal Communications Commission, under new leadership now, has also kind of abdicated regulation in the states. So this bill is very timely. We hope you support it, and thank you very much for listening to us.
Thank you very much, and we would appreciate if you could provide some further testimony.
You will. It's okay. I'd like to provide some later to speak.
Sure. Perhaps you've got plenty of time, but it's very interesting, and we'd like to take a closer look at that.
Absolutely. Thank you so much.
Thanks. Jesse White, and I believe we have two panelists as well. For the people in the audience to get some sense of where we're at right now, we're just taking a category of solitary confinement. So we have many people testifying on that. Afterwards, we will be dealing with the primary caretaker law and mandatory minimums. So if you're here on any of those, you want to step out, you might have time to get a cup of coffee or a sandwich. So I'll give you that. We're probably going to be calling this. So.
Okay. Ready? Thank you again. In my capacity, I feel as a staff attorney for excessive force providers. I work with a large number of prisoners who are living in solitary confinement. I'm never going to forget one of the first men that I ever met who was living in the DDU, which is the long-term disciplinary solitary confinement unit, where prisoners are sent for up to 10 years for a disciplinary offense. For purposes of my testimony, I'm going to call him Mark. Mark spent approximately 6 months in solitary confinement before I met with him for the first time. During that 6 months, he had lost 30 pounds, he had begun hearing voices, and he was experiencing severe anxiety. He was so disturbed by his time in solitary that he began to bite large holes in his own skin, which actively bled beneath his bandages while we spoke. Again, I took photos of the wounds that he had inflicted upon himself, and this is one of those pictures that I took when we met. He was diagnosed with paranoia. He refused to eat or drink because he believed he was being poisoned, and he also refused medical care, resulting in staff using chemical agents and physical force against him to force him to go for treatment of his self-inflicted wounds. The reason that Mark was in the DDU was because officers had accused him of throwing a food tray and striking an officer, and then resisting and biting an officer after they took him to the ground, causing a small red mark on one officer's wrist and pain, redness, and swelling on another officer's elbow. Mark had denied these allegations and alleged that he had been assaulted by staff. He had suffered a facial contusion and a fractured and dislocated elbow that required surgery and physical therapy. There was no video of the incident, and years later, the officer that Mark had accused was removed from prisoner contact after having many reports against him. Mark was found guilty of assaulting correctional staff and sanctioned to 1.5 years in the DDU. When we met, Mark told me that there were not enough beds for him in a mental health unit, so he was not going to be transferred to one. Only after PLS's executive director advocated for him was he moved to a treatment program finally, and after we sent these pictures to the DOC. There's no evidence that solitary confinement is necessary to control or reduce prison violence. The solitary confinement reform legislation before you this session does not prevent the DOC from holding a person in solitary if it shows that person is dangerous. The person in the DDU, however, is not to contain actively violent persons. The DDU is intended to punish, and is intended to punish past violent behavior with lengthy terms of extreme deprivation that will not be reviewed or reconsidered regardless of current behavior or current risk. When a violent act occurs, it is a natural human response to react emotionally and want to punish the offender. But I hope that the Commonwealth is beginning to realize that we must focus our resources on rehabilitative justice rather than punitive justice. Thank you.
Thank you. Good afternoon, Representative Claire Cronin. Good afternoon, Senator Ron Berger. Good afternoon, panel, audience, and all those under the sound of my voice. I'm here today to talk about solitary confinement, and again, I want to echo the sentiment. I hope you will reconsider the use of solitary confinement. My son is disabled, paralyzed, and incarcerated. It's very emotional. I heard testimony today. I don't want to get emotional, but I know that I will. My son was a victim of a crime and shot on the streets of Lynn 18 times and did not want to point out the shooter. I just wanted to get that out today because I saw the prosecutors, I saw the judge. It's very emotional. But I want to talk about the solitary confinement. My son was in the Susan Baranowski minimum sentence because he was carrying a firearm. I want to be very clear. Carrying a firearm after being shot 18 times. My son was incarcerated due to carrying the loaded firearm, purchase in a direct disagreement with an officer was taken to solitary confinement because he wanted to call his daughter. It was her birthday. He was denied a phone call to his daughter. It was the holidays. It was December. They were understaffed. This is what they said to my son. You cannot get the phone call. An argument ensued. He was assaulted, beaten in his face, and I'm getting off track a little bit, but I want to say the 10 days ended up in a long time in solitary confinement. I think it was 9 months. 9 months they came, they said, give us somebody, tell us something. They interrogated him. He had no visitation. They would tell me to call for a visit, but when I got there, they'd say my name's not on the list. They treated me like a common criminal. I want to say my husband's here today supporting me, and I promised I wasn't going to cry, but I can tell you, my son is going up for parole this year, and God willing, he'll come home to us safe. He's not the same person that he was when he went in. He's 26 years old. He's my only son. And thank you for hearing me today. Thank you for taking the time to do this. Thank you.
Thank you for being able to tell the story. Thank you for being with us.
Thank you to the chairs of the committee for this opportunity to testify. A loneliness, it should be a word. That's what the young man opposite in solitary says. I can't tell you his name, but he's the same age as my own son, so I will call him by my son's name, Austin. I started visiting Austin when a friend called because friends of his were frantically looking for someone to visit him in solitary because they were worried he was suicidal, which he was. The last 6 months have opened my eyes about the cruelty and inhumanity of solitary confinement in Massachusetts. I already knew it in my head, but now I know it in my heart. once in a cell so small he could touch all 4 walls without moving. He couldn't walk because the sink overlapped the bed. It used to be a bathroom, so every inch of the walls and floor were tiled. All the sound reverberated loudly up the walls, and I watched as it slowly drove him mad. As week in and week out, he was subjected to the echoing noise of flushed toilets, yelling inmates, banging cell doors. He was literally put in a tomb of torture. There was no escape. The 1 hour yard time is also a mess. For the majority of the inmates, they find it impossible to go outside. Some don't have coats. Some are concerned for their own safety. But most don't go outside because the guards use this as an opportunity to toss their cells, leaving their belongings trashed with items broken or missing. But the worst is the isolation from any human compassion. Once a guard took him to the showers and was polite even next to him, unlike all previous guards. The guard took out a bottle of shampoo, and Austin's heart leapt because he had been denied shampoo for weeks. The guard unscrewed the cap and put it up on the ledge near Austin as if to give it to him. Austin, so grateful for this one act of generosity, reached down to take the shampoo, but just as he reached toward it, the guard knocked the open bottle off the ledge, pouring the shampoo all over the floor. Can you imagine the crushing blow? A human being who is isolated from any form of goodwill, any form of compassion. When he finally thinks he's experiencing a moment of human kindness, only to have it twisted into an act of cruelty. A loneliness, it should be a word. It's not just a loneliness of the body, it's a loneliness of the soul. Human beings aren't meant to endure this kind of treatment, and he must endure it for 4 long years. How does someone get out from this kind of treatment with their psyche intact? I was talking to a friend, cataloging the horrors I was bearing witness to, when another friend overheard and asked, "What country is this happening in?" People can't believe that this torture is happening right here, right now, in our own state of Massachusetts. And I'm asking and begging you to do something about it. There needs to be oversight. The prisons need to tell you what they are doing and who they are doing it to and for how long. And I find it unbelievable that in the year 2017, I am pleading with you to pass a bill that simply calls for humane conditions in prisons in Massachusetts.
Thank you very much for your testimony. Does anyone have any questions? Thank you.
Reverend Jason Martin is next. Oh, I see panel with Monica James, Frank Bliss, Allison, and Douglas Rogers. We'll be one for I'll introduce the panel, and then they'll all speak on their own. Good afternoon, thanks for having us, and be patient for this day. There's a lot to be shared. We're glad to be here. My name is Reverend Jason Leiden. I'm the National Director for Black Community. We're a national network grassroots organization working with lesbian, gay, bisexual, transgender, queer identified folks who are currently incarcerated. We have a network of about 13,000 prisoner members, including 250 here in Massachusetts. It feels very pertinent for us to be testifying today. We're focused on 4 solitary bills that we support all 4 of them moving forward. Today being Juneteenth, a day where we remember the fact that Texas took so long to abolish slavery after the Emancipation Proclamation. We here in Massachusetts are taking so long to end a system of violence that targets Black and brown people. That it seems so appropriate that it be Juneteenth that we're having this conversation about solitary confinement. others of us elsewhere. The conditions that we have heard from our prisoner members about solitary confinement here in the state are clear that it is torture. Torture is alive and well in Massachusetts. That prisoner is subjected, as you've heard, to 23 hours, more often than not 24 hours a day in these cells where they are locked with sensory deprivation, qualities of life, and that we are trying to change some of the conditions of confinement. And that's what some of these bills do, right? Really change what's happening while they're doing time in these cells. And so for myself, I did only 45 days in solitary confinement, but that has lasting lifetime impact in terms of changing the ways in which I engage in the world, had a severe impact on my mental health, somebody with a diagnosis of illness prior to my being held in solitary confinement. And as I promised Myra previously, it does begin having huge impacts on the way that you survive while you're inside. And so it's key that for the work that we're doing, we remember the humanity of prisoners. As so often, they're just labeled as numbers and put away in box. What we're trying to do is continue to tell a different story, that we need to recognize people's humanity while they're doing their time. I think with our, what we saw yesterday in the Boston Globe, on top of the front page of the Boston Globe, we can see that DOC cannot regulate themselves, and that's why these bills are so important. But the DOC can't be trusted to take care of prisoners. So we need strong regulations and we need strong oversight, because without it, we're going to continue to have the same problems over and over again. And your job is to keep everybody safe. So I believe in these bills.
Excuse me, good afternoon. I'm Monica James, National Organizer for Black and Pink. So I want to testify about my experience in solitary confinement. I was placed in solitary confinement based on my gender identity. As a trans woman, I was forced into solitary confinement for 6 months. My first 41 days of solitary confinement, I was denied water. This cell had no working plumbing. I was denied access to medical care and treatment because I was in solitary confinement. And it also became a gateway for guards to harass and punish me based upon my gender identity and their biases toward LGBTQ and IA expanding individuals. Solitary confinement violated my 8th and my 14th Amendment. Solitary confinement is an egregious violation of my basic human rights. And in hindsight of being in solitary confinement, I truly experienced psyche issues dealing with re-entering into society and adjusting because of the trauma that I experienced during my time in solitary confinement. Solitary confinement is no short of a tool, as Jim Crow was back in 1865 and so on. It was used as a vehicle to attack, to harm, to destroy, to torture, to kill, and that's just what solitary confinement is doing today. It is a tool of torture. It is a gateway for harassment, torture, abuse, sexual, physical, and mental and emotional violence. And so many of our brothers and sisters that are inside the penal system today, they report these very same egregious acts on a day-to-day basis, that their dignity is being violated because there's no regulations that hold the police officers or the correctional guards up to accountability. There's no accountability there for correctional officers. And because of that, many people like myself that fall in the LGBTQ family are forced into solitary confinement based upon our gender identity or our sexual preference. And at that time, we are forced into a state of constant and enduring torture. And so it is my hope and my wish and my prayer that you will support the bill to end solitary confinement.
Good afternoon. I'm sure you know this is my first time speaking, but I'm going to sentence. I did a 28 sentence and I didn't believe in solitary confinement. I was placed in solitary confinement because of the fight. I was assaulted and I still out myself. still torture you. Well, that's not what I just speak about, you know. I like to speak about the effects that it has after you're gone. The things that go on in solitary confinement, just the small things that you think are nothing for time affect you forever. I still can't take an elevator. I take the stairs where I go. I can't be in that small room. I can't stand the lights on. The lights are on 24 hours a day. That's all I can't see the lights on. I'm begging you to try it tonight. They say it's 24 hours a day lockdown. It's really not. You're let out into a small dock, you know, that's completely caged in, and you're still shackled with your handcuffs on, and you left to shuffle outside. That's, you know, chain defense still gives me chills down my spine. A lot of the solitary confinement are extremely cold. We have to wake up in the morning and break the ice on the floor just to use the bathroom. Sometimes the water doesn't work like mom and stuff. It affects you because little things, you know, they don't eat the lack of food that you get. You know, 185 pounds when I'm less solitary, I was 150 pounds. To this day, I still bring food into my room at night with me. My aunt's thinking crazy because I don't know if I'm going to be hungry later. When I know I can walk 20 feet to the fridge to get food. The effects that it's had on me, it's not going to go away. You know, I try to consider myself a strong person, and day to day I struggle with the things that it did to me. And I don't want to see it done to anybody else. You know, it's pretty bad. I don't have much else to say. But I just want to share that with you. Thank you very much.
Good afternoon, ladies and gentlemen. I'm here as a survivor from solitary confinement. I was in solitary confinement for 3.5 years. I was moved from different cells every 30 days. The reason I was placed in solitary confinement because one of the guards assaulted me. I reported to the administration. They did nothing about it. I waited a couple months. I went back out to the general population. As I was working as suicide prevention, I experienced a little difficulty with the guards not letting me actually help the individuals that were on suicide watch because they were doing a lengthy sentence. I was sentenced to 15 years, but I also was hospice. I worked at hospice and took care of other prisoners that were dying. It touched me a lot. I work with dialysis patients. The only thing is, when you come out, you cannot get your CNA. But I was a person that cared for the less fortunate that was incarcerated. I worked with numerous people, different ethnic, different background, different religion. So that didn't matter to me. The thing that I took hold to was trying to give something back. Being that I was in solitary confinement, you know, you're locked in 23 hours of lockdown, and you're not given the proper things, your mail, you know, you don't have what you guys got at home, you're not able to communicate with your family, you're not able to communicate with no one besides the prison guards. So when you come out of that type of environment, sometimes that environment makes a person hostile. I know certain people that had testified here today. I was here 3 years ago with the same issue with this bill. And I'm just asking that you take that upon yourselves to really reflect on some of the individuals. I know some people say all people need to be placed in jail because of certain crimes and victims. You know, I understand that, but nobody deserves their dignity taken away from them, their sense of pride, just because of their sexuality or their ethnic background. You know, I'm here as a survivor of solitary confinement, and I know what it does to people. I know what it done to me. I know that while you're inside, you can't get the psychology department to help people. You got people that come out from prison that are mentally ill. We understand that. You know, there's people here, all nationalities, all race of people, but nobody deserves to be treated inhumanely and be locked in a 6x8 cell. So thank you for your time.
thank you for sharing that with us. Does anyone have questions? Any questions? Yes. Kristen, Dave? I think we have a panel here too. It's Lisa Newell, Pope, Joe Laganis, and Elizabeth Mattis.
Hi, good evening. My name is Kristen Day. I've been a licensed mental clinician in the state of Massachusetts since 2001. And here I can talk to you about my experience working as a clinician at NCIC Junction in 2008. As a clinician, one of my responsibilities was to work with the individuals who were in DDU. This included crisis intervention, included meeting with the individuals who got mental health cases, and included rounds. I'm going to actually talk a little bit about some of the testimony that we heard here today, because you've heard a lot. In fact, you have the complete opposite experience of the people who are in DU in isolation. You have overstimulation, where they are completely deprived of it. And here I'm going to talk a little bit about the neurological effects of that. But earlier today, you heard a colleague of mine, a former colleague, Roland Rowe, talk about what it looked like when the men came in from DU. The stark looks of their face, how drawn they looked, disheveled and messy, often going through periods of psychosis. While working in the DDU, I watched these men evolve, become those people who ended up going into the secure treatment program. And a lot of the reasons this happens is because the isolation that these men are going through is exactly what prisoners of war and political prisoners, this is what they experience, because people know that it's a form of torture. Human beings, no matter who you are or what you've done, you require two things. You require social interaction, and you require stimulation, sensory stimulation. That is how we interpret the world, it is how we learn, and how we know what's going on in our environment. And when you take away or restrict that, you don't realize what that does to you. All of us here, you can hear what I'm saying, you can watch me. You can see my facial expressions, you can see my nonverbal communication. When you're stuck in a cell, all you're doing is hearing things, you don't know where it's coming from, and you don't know what's going on. And over time, you start to wonder if those things that you're hearing are real, or if that's just a product of your imagination. Men start to experience auditory hallucinations because they're not sure what's going on for them, and that is a very disturbing experience to have. You heard testimony earlier today about when someone's brother was dying and shot, and they went to go see him. They had to put their hand on the man's heart. And that's because we require touch. We need that. We know that with science. We know from birth to the time that we die. And what happens in isolation is the only touch you get is the officers putting cuffs on you, or the officers coming in to have a riot team come in and take you out. And at times, because you are lacking that touch, your body craves it and needs it so much that you start to experience depersonalization, the ability to feel like you're not in your body. And your mind starts to trick on you. You start to think that bugs are crawling on you. The man who bit out part of his skin was possibly doing that because he wanted to know he was still alive. He may not even realize that the arm was attached to him. And when things get so bad, I'll wrap up by saying when things get so bad, at times we'll have them fight riot team because they know they're about to be hurt or injured, then have to do one more day like that. Thank you for your time.
Thank you.
My name is Jill Gaines. My son Billy spent most of his incarceration at MCI Shirley Medium Facility. He did well there and was looking forward to wrapping up his sentence in the summer of 2016. In August of 2013, he was sent to solitary confinement after an altercation. There he was taunted by officers from outside the cell. He quickly lost 25 pounds after his meal portions were cut. They withheld his medication for anxiety and depression. They lost his slips he put in to see the doctor and to see mental health. He didn't get the treatment for his drug addiction. Billy quickly changed. On the phone, I could hear his spirit just being sucked right out of him. In the small cell where he was 23 to 24 hours a day, anxiety attacks became an everyday occurrence. Things went from bad to worse to intolerable. Conditions he described as inhumane. My heart would break. My heart still breaks when I read his letters. He wrote about his young daughter. Here's some of what he has written. Tell Crystal that I love her, and I'm sorry I won't be able to draw or anything anymore. They had taken away his pencils. It's not her fault, and that sucks. Maybe she's better not knowing me. Maybe it will save her a lot of hurt and disappointment. What they are doing to me in here is ruining my mind. I can't think straight. I'm always so angry and depressed. My thoughts are toxic. If I wasn't so close to finishing this sentence, I'd probably give up and call it quits. Something's wrong with me, and they don't seem to give a shit. So it's getting harder and harder for me to care as well. I've never hated waking up so much, just dread having to face another day. I don't mean to frighten you. I frighten myself a lot lately. Sorry I sound so miserable all the time. But once you put someone who already has mental health problems in a cell 24/7, it amplifies it tenfold. So sorry, all I can do is suffer through it. Love, Billy. Shortly after this letter, he asked me to come see him. He hadn't wanted me to visit him while I was in solitary. But he called me the next day to say, don't bother coming, because he was in medical. He had slit his arms. I felt more helpless than ever. Billy's total time in solitary was 364 days. As his release date drew near, I prayed that his time in solitary hadn't mentally scarred him forever. But it had. Billy was released on July 14th, 2016. He got to spend time with Crystal. It was priceless to watch that bond grow. He had a job. He was looking forward to a good long life with his girlfriend. We thought he was doing well, but in his head, things weren't on. He was found dead on October 6, 2017, of an overdose. To me, there is a straight line between Billy's treatment in solitary and his mental deterioration. His trouble adjusting to life outside, persistence of his drug use, and in the end, his death. I ask you to support these bills to reform solitary.
Good evening. My name is Lisa Newman-Polk, and there, but for the grace of God, go I. That is a thought that I have had in my head for the last 12 years in my two-part career as a public defender attorney and as a licensed clinical social worker working with people with addiction and trauma and co-occurring disorders on an outpatient basis on probation and parole, and also in Susan Baranowski Correctional Center in the Men's Maximum Security Prison, where I worked for 14 months. I am here to talk about solitary confinement, but I do want to touch upon the very, very severe addiction problem that we have that goes very untreated within the Department of Correction. It's a waste of our resources if we're not doing something about that and actually providing treatment. And I can't tell you how many clients I work with who begged for treatment and I could do nothing despite my advocacy. In terms of solitary confinement, I want to be very clear that I don't need to explain to you why it's inhumane. We all know that being locked in a bathroom, a cement bathroom, for 23 to 24 hours a day, and only being able to go out in a cage is inhumane. We're a civilized society. We all know this. What I would like to talk about, though, is the safety risk to all of us. The men that I worked with, most of them who would come back from the Department of Disciplinary Unit and come back to Susan Baranowski, they were not safe for individuals to be around. It did not make them safer to go to solitary confinement, because what happens? You either go to the DDU and you adjust to it really well, which is what they want, or you go and you don't adjust. And let me tell you, if you don't adjust, you do things like my clients would do and Kristen talked about, which would be constantly, we want a move team to come in on you so you can have some physical interaction. So we're having fights started just to get some sort of stimulus, to have some way to get out of the cell. That's not considered good behavior, obviously, and creates more disciplinary tickets. However, if you adjust well to the DDU, that is not good for us, because then you don't adjust well to coming out of the DDU. The men that I worked with who came out of the DDU were not safer. They didn't want to be around people. They didn't want to be around the other men at Susan Baranowski. And I cannot tell you how many men I worked with who would say, I'm going to stab someone or I'm going to break someone's arm so I have to go back because I can't now deal with being around population. So it is not a safer place to put people. It creates more insecurity within the facility. And I want to be clear that these aren't men, particularly that I work with, that we should not be giving up on. We have men wrapping up their sentences and going straight back into the community from solitary confinement. So many. The Department of Correction is skirting its duty to actually try to better people before they go into society, when they let people go back to society from a solitary cage. This is a travesty, and I'm working with a young man right now named Shaquille who's allowed me to talk about him. He's 22. He wrapped his sentence from solitary. He had no probation, not that I think that frankly would help him. Who was nailed to Gap Community Services? I, his attorney from a year earlier, when by the way he found not guilty of the charge that sent him to 2 years in the DEU. I apologize for over time, but needless to say, there's much more to be said. Thank you.
Thank you very much for your story, for sharing with us, and for your knowledge and explaining the process, what it was for someone as they sit there. Could you leave your contact information, please, with the gentleman at the end of the app? Yes. Okay, well, I'm sorry.
So I'll be brief, but in wrapping up this panel regarding mental health issues, it's important to say that the department between 2008 and 2010 did open up 3 treatment units designed to divert prisoners who are seriously mentally ill, otherwise known as SMI, from segregation. And by the department's own standards and their mental health providers, these units have been very successful in reducing the incidence of suicide, self-harm, and violence. The problem is that there are only 29 beds between all 3 units. And we know that there are over 9,000 people in the DOC, and that by very conservative estimates, 20% have mental health issues. And so you're talking about roughly 1,800 people, right, for 29 beds. And we've already heard about some of the things that happen to people in there. This is a very common thing we've had with our clients at PLS as well. Incoherence, extreme paranoia, smearing feces on their own feces on themselves and on their cells is a very common, unfortunate phenomenon, in addition to the self-harm that we've already heard of. And it's worth noting that the rate of suicide in solitary cells is higher than in any other setting inside or outside of prisons. And then in the county facilities, unlike the DOC, there's no screening mechanism for even the severely mentally ill. There's nothing. But the counties currently hold more prisoners than the Department of Correction. And those people are virtually all going back to their communities after serving their relatively short sentences. And solitary confinement is alive and well in the counties as well. And I just want to say, 16 years ago, in a 2001 opinion, federal Justice William Wayne stated that solitary confinement units are virtual incubators of psychosis, seeding illness in otherwise healthy inmates and exacerbating illness in those already suffering from mental infirmities. And this sentiment has been echoed many, many times since then by correctional administrators, wardens and commissioners alike, by medical experts, by Justice Kennedy of our Supreme Court, by President Obama, the United Nations Special Rapporteur on Torture, and the Pope himself. The evidence is incontrovertible that we are, as a Commonwealth today, not only exacerbating mental illness, but we are creating mental illness in the many hundreds, if not thousands, of prisoners in our jails and prisons today. I think the floor for change should be passing the solitary data bill, because it's nonsensical that we have no access to this information. We don't know how long people are in there, who's in there, and why.
But passing just a solitary bill will do nothing to stop the damage that's being wreaked on these individuals every day. And so I implore you to do more than just pass a solitary bill. At the very least, that should happen. So that to do nothing less, I really feel, with all due respect, that the social order. Thank you so much for listening to the testimony today.
Thank you very much. Does anyone have any questions? Thank you. Mary Valerio.
Good evening. I'd like to thank everyone for giving me the opportunity to speak today. And I'm here representing the Actual Justice Task Team of the Massachusetts Conference of the United Church of Christ. And one of our missions is to work with people who are wrongfully convicted. I became involved with this group because I have a family member who is wrongfully convicted, having been convicted in absentia for a crime that he did not commit, and was actually being deported out of the country 20 years ago during the trial. Then the Worcester District Attorney's Office, after 20 years, brought him back into the United States by giving incorrect information to the State Department. So as we resolve this case in court, I've done a lot of visiting at the state prison. And in the course of the many days and months that I've been there, I've done over 1,200 visits to state prison. And in all of that time, you meet a lot of people and you hear a lot of things about how their family members are being treated. And some of the things that really occurred to me, why I feel they should support House 74 are the reforms around good time and other incentives that will help people to get out of prison sooner. And also in support of the bills around solitary confinement changes, because clearly I've seen and heard people put into solitary for non-violent offenses. And my own personal feeling is where Massachusetts is always first in education, top of the line in healthcare, I think this is really an opportunity to be #1 in criminal justice reform, because there just are not enough programs that help for people, and even people on long waiting lists should perhaps get some credit for waiting to get into the programs, because they are clearly not preparing people well enough to go back out into society. So in conclusion, I would just say that there is a need for more programs and for programs that prevent recidivism. And I think that if we're really courageous and do the right thing, Massachusetts will be a leader in this area as it is in many others. Thank you.
Thank you very much, and thanks for staying on the time. We have a panel here, the National Association of Social Workers, Sarah Coughlin, Norma Watson, and Christine Park.
Thank you so much, and thanks for being here so late with us. My name is Christine Park. I've testified before this committee before, and thank you for your time. I am the political director at NASW, and our organization represents 7,000 social workers from every district across the state. And many of our members work in jails and correction facilities or in the community with people who have been released from jail. And I have a lot of data about the impact of solitary confinement, which I think you've heard a lot of today. I do want to say that as an organization, we support several of the bills being heard today, community-based alternatives for caregivers, an end to mandatory minimums, medical release of terminally ill and incapacitated inmates, but most important to mentally solitary confinement. It's an issue that we have, our criminal justice committee, made up of social workers who work in the criminal justice system, has prioritized. Because of the link that you've heard of between mental health issues and solitary. In some of the reports that we've looked at, and from the personal stories from social workers, it's clear that mental health impacts begin within a week of being in solitary confinement. And so we as an organization believe that solitary confinement should be no longer than a week, ever. And that to try, I think the most compelling testimony today was the testimony from Maine that showed that with the huge drop of the use of segregation in Maine facilities, that violence has gone way down and safety has improved. I'll stop there and we will submit written testimony with some of the statistics and data and personal stories. And I'll turn it over to Sarah.
Hi, thanks so much for having us today. My name is Sarah Coughlin. I'm a licensed clinical social worker and licensed drug and alcohol counselor. I work for Mass General Hospital as well as Justice Resource Institute, and I've been working with incarcerated populations for the last 10 years. Today I'm going to testify on the need for solitary confinement reform. I'm testifying on behalf of my client who's currently residing in inhumane conditions at 10 Block at NCI Cedar Junction. He was not aware of the 3-minute limit, so his letter is 28 pages from that, but I pulled out a few really important quotes from his testimony and his experience currently residing in 10 Block. The 10 Block cells are a little more than closets with plumbing, uniformly small and windowless. The average sized man can stand in the middle of the cell and touch the parallel walls. Movement is severely limited, and any exercise is performed with extreme caution, if at all. When you first walk into 10 Block, the first thing you'll notice is the smell. It's the worst combined smells of a locker room in a hospital. Urine, feces, sweat, metal, disinfectant. It's a smell of 15 men living in a poorly ventilated communal hallway for months at a time. It permeates the entire place, and after a few weeks, your brain recalibrates and it becomes your new baseline percent. Your noise becomes super sensitive to anything foreign. Even a small amount of perfume or a hint of cigarette smoke can be almost overwhelming. He talks about the noises that he experiences residing in solitary. He talks about the food. He talks about having to ingest toilet paper on a daily basis because the pain from his hunger is too much for him to manage. He talks about the variety of health problems that him and his fellow inmates continue to be problems with. His high blood pressure and obesity are rampant. He talks about the small moments where they can get some air. He talks about the yard that consists of a paved area behind 10 Block with 12 chain link cages that resemble nothing so much as a dog kennel. Each cage is roughly 9 feet wide by 20 feet long and is designed to hold one inmate. There's no grass, no trees, no place to sit. It's not much, but it's your only chance to look at anything more than a few feet away from you. Your only chance to breathe fresh air, to feel the sun on your skin, 1 hour a day, 5 days a week, weather permitting. Spent in a cage on a parking lot. He talks about the effects of these periods of segregation and isolation can be profound. Lack of exercise, mental stimulation can cause a wide variety of problems. He talks about being released from there, which he has in 12 times. There's so much more in here, but I will say his last is that with so many issues in our criminal justice system, it's easy to forget about the people who are already locked away serving sentences. Out of sight, out of mind. But most of us are coming home someday, and we will carry with us the scars of our ordeal.
Hi, I was here 2 weeks ago, as all of you were as well, as a founder of the Massachusetts Bail Fund. I'm going to speak today as a member of NSW, but also from my position of the Director of Social Service Advocates for the Committee for Public Counsel Services Public Defender Division. I'm I'm speaking for myself, not for the agency, but I'm speaking from that foundation of experience. Given my work in all the counties in the state except Dukes County, we work with people who are facing through trial. So I wanted to mention just two other things to underscore. Solitary meets cruel and unusual punishment criteria, in my opinion. When we're representing people through trial, we have individuals who actually deteriorate and can't go on with their court case, or they're found not competent and starts a vicious cycle. In addition to what happens with people who might meet the consequence, we have people put in solitary for administrative issues, not because of behavior. We have them put in as a consequence and automatic. One of my clients was using Suboxone, automatic 30 days, regardless of their mental status. We see people's mental status deteriorate and medical problems go up. And as a taxpayer, I don't want to fund this type of treatment. The other thing that happens, because solitary exists, we have people who have been victims or sexual abuse rather. They feel they're going to be abused. The only place for them for safety is often solitary because that exists. So those two individual cases are an example. While I'm here, I just want to mention my support for passing mandatory minimums. What happens is that I work in all the counties, and daily for the past 10 years, judges say to me, I wish I don't have to give you this time. They talk with us, we're sentencing advocates, mitigation specialists, we identify issues related to the crime, past history. The judge says, or a court says, or she says, I wish I was not forced to do this. Also, with the caretaker's bill, in addition to your testimony here, I want to make sure that children aren't neglected besides the women, but we see incredible attachment disorder, major issues related to kids. Often the friends and relatives can't take care of them, and they're put in an overburdened system of DCF. And what we see is a high rate of separation of siblings not being able to stay together because the caretaker is not available or they have the resources for alternative. Thank you very much. Do you have a question?
I don't have a question. Does anyone else? Thanks very much. Michael Carey. Susan Cordella. She left. Okay, we have a panel. Alan Epstein, Frank Lasky, Beverly Williams, Bernadette Hickman, Reverend Burns Stanford.
Good evening, Chairwoman Cronin, Chairman Brownsberger, members of the committee. My name is Alan Epstein. I represent and am co-chair of the Criminal Justice Task Force of GBIO, the Greater Boston Interfaith Organization. For nearly 20 years, GBIO has worked for the public good by training and organizing people across religious, racial, ethnic, class, and neighborhood lines. Our 39 churches, mosques, synagogues, and community organizations represent tens of thousands of individual constituents. We are here to support Senate Bill 819, Senate 1296, 1286 on mandatory minimums and solitary confinement and house equivalents. I'm actually not going to read my notes. I'm going to abridge them due to the late hour. I just wanted to indicate a couple of things. One, the fact that we have still solitary confinement represents to me an inability to realize that what we're dealing with are human beings. And if you cannot see prisoners as human beings, you will let this system continue. And finally, I just want to set the record straight. I read John Pfaff's book. I attended a panel at Harvard Law earlier this week that John Pfaff made a presentation at. In fact, he argues persuasively
that mass incarceration is caused by prosecutor overreach and over-sentencing. So I encourage you all to read this book, Locked In, and I think you'll find the real facts. Thank you very much.
Chairman Rutherford and Chairwoman Cronin. My name is Frank Lasky. I'm also here to testify on behalf of GDIO's Criminal Justice Task Force, specifically on Senator Green's bill, Senate 819, and Representative Bowles' bill, 741. And I have been here since the beginning. I know you've heard a lot about this, so I'll try not to repeat. But we have prepared, GDIO prepared a fairly extensive statement in which we have taken each of the points that the Mass District Attorney Association has made in opposition and responded to them point by point. And you heard many of these points today by District Attorney Congress. So my major purpose of being here is to ask you to take a look at that as you evaluate it. And I'm going to limit it to a couple of points which I think are important from this perspective of the communities, whether from prosecutors or from defense counsel and the bar associations. And everybody, I think, recognizes that the prosecutors charging crimes with mandatory minimum penalties for drug offenses is a weapon that they really treasure and think they need. But DA Conley did not recognize that this weapon has had really widespread use without regard to the collateral damage it inflicts on our communities. And you've heard about that today. This has been a long war on drugs, as somebody mentioned. We're into it 45 years since President Nixon started in the 70s. And from that very period of time, prosecutors have continually sought unreviewable powers to charge and secure tough sentences for all types of drug offenses. And you've heard this again and again. I'm going to say it. There is no evidence, none at all, about the effectiveness of these sentences on deterring and curtailing the business of high-level drug traffickers. And on the contrary, we have a great deal of evidence that the collateral damages from these mandatory minimums has been devastating to persons addicted to drugs, their families, and particularly communities of power. District Attorney Conley says mandatory minimums are only used to prosecute high-level violent drug traffickers. The colloquy with Senator Diaz this morning, I think it was very instructive because he would never back off of the proposition that these are high-level violent drug traffickers. He never went into the various ways that we have. And Representative Day's request for simple information about the charging and who it is affecting is the key here. There is possession, there's possession with intent to distribute, there's distribution charges, there are trafficking charges all over the place. And he should be able to come up and say, this is who is affected. And that has not been the case. I just want to make one point. We've talked again about racial disparity. Our statement has that played out in space. But I want to make one point about another piece of collateral damage. That's mothers and children. And we've heard a lot from Senator Khan and a little from Peters, but 1/3 of female state prisoners are serving drug-related sentences. Of those, over half are serving mandatory sentences. That's another question, Representative Day. Who are these sentences? What are they serving for? It's time to do it. The testimony today, what I've heard today, what you've heard today, the only opposition is from the DAs and the kid. If you look at our statement, take it on a factual basis, you'll find that this is the time to act.
Good evening. My name is Beverly Williams, and I am totally off script. I can take this right now. Because over and over again, we have been hearing the same thing. But then I keep also hearing the same thing. I keep hearing from DAs and even some legislators that this is the wrong time to do something right. And I dare to say that it is the wrong time not to do something right. I have grown up in Boston. I was raised here. I was born here. I was raised here. I lived in the Boston projects, I taught in Boston Public Schools, I'm a retired school teacher. Some of these people that we are talking about, I have lived with, I have taught. And there is crime happening all over the city. There is higher crime in downtown Boston around property crimes, but the arrest rate is much different. I do believe that it is designed to, and purposely, and I'm taking it personally, I guess because I'm a person of color, but I live in a neighborhood called Ashland